major decision from the Supreme Court that could have larger implications on gun laws nationwide.
But public safety concerns must be addressed in ways that are lawful. This rule is not.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
It's a case that legal experts will be watching closely.
This year, California tried once again to reshape how gun ownership looks in the state, moving past old strategies and pushing new rules that affect nearly every gun owner. From added fees and tougher training requirements to restrictions targeting popular handguns and firearm parts, lawmakers aim to rebuild a complicated wall around gun rights. But while Sacramento pressed forward, courts and constitution-based challenges are steadily unraveling much of this effort. What really happened behind the scenes? Which new laws survived and which ones got stopped dead? And why should anyone outside California care about these legal battles? This isn't just a story about state politics. It's about the future of Second Amendment protections under renewed scrutiny. Let's start with what almost slipped under the radar, the bills that never got through. California's lawmakers came ready with familiar tactics. If banning outright was impossible, then the plan was to make gun ownership more expensive, inconvenient, and subjective until regular folks gave up. But this time, many of those ideas failed, creating a significant pause in California's push for extra gun control. One notable failure was AB 10006. It appeared on paper as a way to clarify the concealed carry permit process influenced by a recent Supreme Court ruling. But its real aim was to reintroduce vague, good moral character assessments by local officials, letting them dig into a decade of an applicant's past and nitpick minor mistakes on paperwork. Anyone familiar with unfriendly sheriff offices knows how that could translate into outright denials for perfectly lawful applicants. Luckily, AB 10006 died before it could become law, preserving a fairer and less unpredictable process for permit seekers. A B1187 was another that didn't make it.
A three-judge panel ruled that the state's ban on magazines holding more than 10 bullets strikes at the core of the right to bear arms.
The panel's majority ruled Friday that the law banning magazines holding more than 10 bullets violates the constitutional right to bear arms.
There's nothing in the Second Amendment that says that you can ban magazines or any crucial part of a firearm.
Red dot optic is just like this magazine. It makes the firearm more dangerous when it's misused, but it also makes the firearm work better.
Any law enforcement officers in California, including feds, you are absolutely prohibited from enforcing restricted magazines ownership in California, regardless of when they were purchased.
California already requires first-time buyers to pass a written firearm safety test and pay a small fee. This bill would have upped the ante dramatically, pushing for live fire training hours and more costly classes. While branded as reasonable training, it risked putting constitutional rights out of reach for people living paycheck to paycheck, single parents and retirees alike, who might have to choose between basics like food and fees. This bill also fell by the wayside, meaning that hurdle remains unchanged. Some proposals seemed less threatening on the surface but carried hidden consequences. Take SB 320, dubbed the Do Not Sell list. The idea was voluntary. People could flag themselves as temporarily in crisis to prevent firearm purchases. But who decides when someone gets off that list? Can access to that information be controlled? Could it later be used unfairly, say in jobs or custody cases? The problem is that databases like this rarely stay voluntary or narrowly scoped once states build them. Fortunately, SB 320 never crossed the finish line.
Not giving notice, well, that's required. Well, and when you take that away from people, you don't follow the rulemaking process, and you have to invalidate the rule.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
The government may not regulate individuals' possessions of weapons for self-defense.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
Give us transparency in how you're going to handle them. And if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fairer process for everyone.
Then there was SB 248, which tried to direct taxpayer money to send warning messages about gun dangers, effectively government-funded anti-gun propaganda aimed at residents. Using public funds to message citizens like this raises clear concerns about fairness and bias. This bill also failed to advance. So even before looking at laws that did pass, California's broader approach to tighten concealed carry rules, increase costs, build sensitive databases, and fund anti-gun messaging largely collapsed due to pushback from gun owners, civil rights groups, and reasoned voices in the legislature concerned about due process and privacy. Now, the bills that did survive the legislative gauntlet reveal where Governor Gavin Newsom's priorities lie. Amid vetoing hundreds of bills on issues ranging from housing to AI regulation, he chose to back stricter firearm laws, showing a willingness to sacrifice other progressive causes to advance gun control.
Saying setting a higher threshold in an emergency could mean life or death.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
It also puts state laws in jeopardy that are similar to this law.
Topics ranging from gun rights and private property laws to foreign property confiscation.
They really don't know what to do with this one, which is always a good thing to see.
Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines.
The centerpiece is AB 1127, colloquially known as the Glock law. Instead of straightforwardly banning one of the most popular handgun types in America, the bill uses technical language focusing on semi-automatic pistols that can be converted to fully automatic weapons. What it really targets are designs like Glocks and similar striker-fired pistols using a cruciform trigger bar. The argument leans heavily on criminals illegally modifying guns, but the practical effect is cutting off legal sales of widely owned handguns crucial to self-defense. A coalition of pro-Second Amendment groups immediately challenged this law in court through the case Jaime v. Bont, relying on a Supreme Court precedent that protects arms in common lawful use. This showdown will test whether a state can pick a particular gun family to ban without banning all handguns outright, an outcome with nationwide implications. Next is SB 74, which redefines barrels as firearm precursor parts. What sounds like bureaucratic jargon has big consequences. Replacing a worn barrel, buying a spare part, or changing calibers will now count like purchasing a whole gun. That means background checks, dealer involvement, and state tracking for something traditionally treated as simple maintenance. Courts will have to decide if this regulatory expansion fits with historical firearm laws protecting ordinary repair and ownership.
This is big.
We won't see changes overnight, but it's going to be quick.
PF and the government is going to fight this every step of the way. And sooner or later, it will land before the Supreme Court.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
This case could reshape how far states can restrict your right to carry.
My response to that is that's the same claptrap that they have been using for 20 years.
Then there is AB 1263, which ventures into First Amendment territory by criminalizing distribution of technical information, CAD files, code, instructions that enable manufacturing prohibited firearms online. This follows earlier debates about whether computer code is a form of protected speech. California is trying once again to limit what knowledge can be shared, turning the gun rights fight into a free speech battle. It's not just about guns anymore, it's about whether government can criminalize certain kinds of information. Finally, AB 1078 attempts to revive a one-gun-a-month limit that was struck down in Re-Bonanza. Instead of backing down, lawmakers repackaged the same idea to ration firearm purchases over time. This sends a clear message. When courts reject one law, the legislature is ready to pass similar laws in hope of surviving future legal fights, forcing repeated litigation, and keeping gun owners under constant uncertainty. Given this aggressive legislative push, the key question is where the good news lies. The answer comes from the courts and evolving judicial standards for reviewing gun laws.
It triggers something in me that something has to be done.
A federal judge ruled California's ban on magazines that can hold more than 10 rounds is unconstitutional.
It could be used to strike down the entire ban, which would allow Californians to buy high-capacity magazines.
If a magazine can be considered an arm or not, the attorney representing Gators Custom Guns in Cowlitz County argued that magazines are essential and a common part of a firearm, therefore a protected right.
When things sound really good for gun owners in court, that doesn't mean it's over.
Take the case Road v. Bont, challenging California's complex ammo background check system. This regulation treats every ammunition purchase like a new gun transfer, complete with constant checking and fees that often block lawful buyers due to database errors. A federal district court ruled the system unconstitutional and issued an injunction before appeals could proceed, signaling judicial skepticism about micromanaging ammo buyers without historical precedent. Similarly, in Re-Bonanza's rejection of the one-gun-a-month rule highlights courts' insistence on historical tradition, not just modern policy rationale. The Ninth Circuit has found no deep-rooted American law supporting rationing gun purchases for law-abiding citizens. This precedent threatens the new version in AB 1078. Then Jaime vs. Bont will shape the outcome for the Glock ban in AB 1127. If the court rules that states cannot single out a common lawful handgun family for banishment based on theoretical misuse, it sets a powerful precedent nationwide. This could protect millions of gun owners and popular platforms from being selectively banned.
This is currently the rule until they decide to change their minds, which they inevitably probably will.
Constitutional protections of your home are absolute.
So the Supreme Court has issued an order in the critical Second Amendment Preservation Act challenge that was pending in front of their court.
This is a case that's been bounced around back and forth throughout the court system.
Breaking news from the State House, one of the big bills in front of the Senate.
The Supreme Court today handed down a major victory for gun control advocates.
Everybody has a right if they're a responsible adult.
Other ongoing cases like Miller vs. Bont challenging California's assault weapon ban, Boland vs. Bont attacking the handgun roster and extra state-imposed safety requirements, and the combination of Rode, Bonanza, and Jaime cases establish a growing judicial firewall against California's wide-reaching gun restrictions. These challenges force the state to defend laws that evolved under different legal standards, now meeting closer scrutiny. Zooming out reveals a stark contrast. California's push for more fees, tracking, bans, and data collection runs headlong into a Supreme Court framework recognizing Second Amendment rights as fundamental. The legislature and governor strive to expand restrictions, but face a judiciary increasingly unwilling to rubber stamp those efforts. Every overreach becomes a new legal battle, and together those battles chip away at what were once untouchable gun control measures. The essential takeaway is that California's gun laws are not impregnable. Many harsh proposals died before causing harm. The laws that did pass face strong legal challenges, and the Constitution, now interpreted more robustly, remains a firm check on excessive state power. The fight continues, and it's crucial for supporters of gun rights to stay informed, back the ongoing lawsuits, and make sure lawmakers feel the pressure of public scrutiny. Every attempt to push restrictions closer to the edge draws new courtroom questions demanding clear historical validation that these laws never fully pass. That's it for today, folks. See you in the next video.